I know you guys can hear me here, so I'm fixing the audio real quick. I've got it, guys. I'm fixing it. Okay. Okay, there it is. I know you guys can hear that. Okay. So what I was figuring I would do is just go through the decision and you know, take a look at the logic that they've used to come to this, and we can kind of talk about what this might look like going forward. All right. So what we do know so far, uh, they found the New York's good cause requirement to carry a firearm unconstitutional. On top of that, it does appear that they have found and announced a right to carry a firearm in public outside of the home. So that's good. What we're going to do is we're going to see how they got to that conclusion. We're going to see what the standard is for how it gets applied going forward. But to do that, we're going to have to sit here and go through the main opinion together, because this is the first time I'm reading it in depth. I figured I may as well read it with all of you guys, and we'll kind of talk through what this means going forward, what the implications are going to be. Does that sound good? Yeah. Okay. So let's read. Of course, this is the background. Here, let me pull this over right here. This is the background. Talks about New York's carry law, where you have to have good cause to carry a firearm, and it's very difficult in New York. They have multiple levels of carry permits, and they have the unrestricted permit that lets you carry it in public. There's only a couple of counties that'll really let you have that. So, as we know, the petitioners were adult people who both applied for unrestricted license to carry a handgun in the public. The state denied both of their applications for unrestricted licenses because they failed to satisfy the proper cause requirement, which we know in plain English means that they were not rich enough. They did not have enough friends in the government, right, to be able to get this license. That's what we know. So they sued state officials and the departments who oversee this for declaratory and injunctive relief, basically to prevent them from continuing to deny these licenses, saying it violated the Second and 14th Amendment rights by denying their unrestricted license applications. Of course, the lower court dismissed it because that's what they do. It's a gun case. They just dismiss them. Held, New York's proper cause requirement violates the 14th Amendment by preventing law-abiding citizens with ordinary self-defense needs from exercising their Second Amendment rights to keep and bear arms in public for self-defense. This is big, my boys. So, and this is this is the syllabus where it's kind of like crunched down, right? And it's like the least crunched down syllabus that I've seen. This is where the actual opinion starts. So this is where we're going to find the actual standards and stuff like that. But I kind of want to read what other opinions were written. So Thomas, big man, delivered the opinion, to which Roberts, Alito, Gorsuch, Kavanaugh, and Barrett joined. So we got a 5 majority. Alito fired a concurring opinion, probably where he just wanted to suck off cops. Kavanaugh fired a concurring opinion. And a lot of you might not know, he is actually one of the main people who's responsible for Heller going the way that it did. So, interesting to see what he said. Barrett fired her own concurring opinion. Breyer fired a dissenting opinion in which Sotomayor and Kagan joined. Interesting. I thought that there would be more dissenting opinions. Those are going to be fun to read, right? There's going to be some coping. There's going to be some seething. So let's just get straight into the opinion. Do you guys want me to read it aloud as we go, or just kind of do the highlights? I'm not a streamer. I'm not a boob or foot streamer, so I'm not. Do we have opinions? Okay, read the whole thing. All right. In District of Columbia v. Heller and McDonald v. Chicago, we recognize that the Second and 14th Amendments protect the right of an ordinary, law-abiding citizen to possess a handgun in the home for self-defense. In this case, petitioners and respondents agree that ordinary, law-abiding citizens have a similar right to carry handguns publicly for their self-defense. We too agree, and now hold, consistent with Heller and McDonald, that the Second and 14th Amendments protect an individual's right to carry a handgun for self-defense outside the home. The parties nevertheless dispute whether New York's licensing regime respects the constitutional right to carry handguns publicly for self-defense. In 43 states, the government issues licenses to carry based on objective criteria. But in 6 states, including New York, the government further conditions issuances of licenses to carry on a citizen showing some additional special need. Because the state of New York issues public carry licenses only when an applicant demonstrates a special need for self-defense, we conclude that the state's licensing regime violates the Constitution. And again, that's just the opening paragraph, so we don't have the legal background for that just yet. New York State has regulated the... Oh, this is good. They're going to go back to the Sullivan Act. This is good. New York State has regulated the public carry of handguns at least since the early 20th century. In 1905, New York made it a misdemeanor for anyone over the age of 16 to have or carry concealed upon his person in any city or village of New York any pistol, revolver, or other firearm without a written license, issued to him by a police magistrate. In 1911, New York's Sullivan Law expanded the state's criminal prohibition to the possession of all handguns, concealed or otherwise, without a government-issued license. New York later amended the Sullivan Law to clarify the licensing standard. Magistrates could issue to a person a license to have and carry concealed a pistol or revolver without regard to employment or place of possessing such weapon, only if that person proved good moral character and proper cause. And I'm not sure how many of you guys know about that, but the Sullivan Law, in practice, was only used to prevent the access of firearms by one class of people. Do any of you guys know which class of people that is? Italians. It was an anti-Italian law, and that's like hyper documented. This is the origin of yeah, correct guys, correct David, correct I'm a dude, correct Dr. Death. This is the origin of modern carry law and anti-Italian racist law. So that's really something. Gun control has wonderful roots, doesn't it? Today's licensing scheme largely tracks that of the early 1900s. It is a crime in New York to possess any firearm without a license, whether inside or outside the home, punishable by up to 4 years in prison or a $5,000 fine for a felony offense, and 1 year in prison or a $1,000 fine for a misdemeanor. Meanwhile, possessing a loaded firearm outside of one's home or place of business without a license is a felony, punishable by up to 15 years in prison. A license applicant who wants to possess a firearm at home or in his place of business must convince a licensing officer, usually a judge or law enforcement officer, that, among other things, he is of good moral character, meaning, of course, in the history of New York that you were not Italian, has no history of crime or mental illness, and that no good cause exists for the denial of the license. I'd also like to step aside right there. The good moral character provisions were then adopted by many jurisdictions in the South to deny licenses to anyone that they deemed colored. And the test would be of good moral character, and it would simply be that a local police officer would attest that, no, his character's not moral. They didn't actually say, the quiet part. It just was what it was. And it's terrible. In fact, in the Supreme Court of Florida recognized that the old good moral character law that used to be on the books in Florida was only ever used or intended to disarm African Americans. So, moving on here. If he wants to carry a firearm outside his home or place of business for self-defense, the applicant must obtain an unrestricted license to have and carry a concealed pistol or revolver. To secure the license, the applicant must prove that proper cause exists to issue it. If an applicant cannot make that showing, he can only receive a restricted license for public carry, which allows him to carry a firearm for a limited purpose, such as hunting, target shooting, or employment. But New York courts have held that an applicant shows proper cause only if he can demonstrate a special need for self-protection, distinguishable from that of the general community. This special need standard is demanding. For example, living or working in an area noted for criminal activity does not suffice. Rather, New York courts generally require evidence of particular threats, attacks, or other extraordinary danger to personal safety. When a licensing officer denies an application, judicial review is limited. New York courts defer to an officer's application of the proper cause standard unless it is arbitrary and capricious. In other words, the decision must be upheld if the record shows a rational basis for it. And for those of you who don't know, rational basis basically means the government wins. Like it's if you could imagine, rational basis means if you could imagine a reasonable excuse for doing something, it's legal. All right. And it's not even, the government doesn't even have to allege a reasonable excuse. Like the government could have alleged that it did it because the sky is purple and that it was afraid of pixies. But if the judge could then go, well, hold on, it might have been because that guy like maybe, was dangerous, then the law still gets upheld. It's not a legal standard. It's the worst trash in the world. The rule leaves applicants little recourse if their local licensing officer denies a permit. New York is not alone in requiring a permit to carry a handgun in public, but the vast majority of states, 43 by our count, are shall-issue jurisdictions, where authorities must issue concealed carry licenses whenever applicants satisfy certain threshold requirements without granting licensing officials discretion to deny licenses based on a perceived lack of need or suitability. Meanwhile, only 6 states and the District of Columbia may issue licensing laws under which authorities have discretion to deny concealed carry licenses even when the applicant satisfies the statutory criteria, usually because the applicant has not demonstrated cause or suitability for the relevant license. Aside from New York, then, only California, the District of Columbia, Hawaii, Maryland, Massachusetts, and New Jersey have analogs to the proper cause standard. All of these proper cause analogs have been upheld by the courts of appeals, save for the District of Columbia's, which has been permanently enjoined since 2017. Really interesting thing there, guys. DC lost, right, at the Court of Appeal. And do you know why they didn't go and appeal it higher? Because they were afraid that if they appealed it and lost again, that other states would have their may issue licensing in jeopardy. Which is a bit odd, isn't it? Because that's not your job, right? So they knew this crap was no good. They knew it was unconstitutional. They knew it from the beginning. Yep, Mark is exactly right. Mark is actually... Mark, you got a DC permit, didn't you? I remember all that crap. As set forth in the pleadings below, petitioners Brandon Koch and Robert Nash are law-abiding adult citizens of... I hate New York. Douglas County, New York. Koch lives in Troy, while Nash lives in Averill Park. Petitioner New York State Rifle and Pistol Association is a public interest group organized to defend the Second Amendment rights of New Yorkers. Both Koch and Nash are members. In 2014, Nash applied for an unrestricted license to carry a handgun in public. Nash did not claim any unique danger to his personal safety. He simply wanted to carry a handgun for self-defense. In early 2015, the state denied Nash's application for an unrestricted license, but granted him a restricted license for hunting and target shooting only. In late 2016, Nash asked for a licensing officer to remove the restrictions, citing a string of recent robberies in his neighborhood. After an informal hearing, the licensing officer denied the request. The officer reiterated that Nash's existing licenses permitted him to carry concealed for purposes of off-road backcountry, outdoor activities similar to hunting, such as fishing, hiking, and camping, etc. But at the same time, the officer emphasized that the restrictions were intended to prohibit Nash from carrying concealed in any location typically opening to and frequented by the general public. So guys, here, the boys in New York really done did themselves. They showed their hand too hard. They played it too hard, and that's why they're getting a spanking right now. They were basically saying, oh, it's equivalent, right? Because you get to go in the back roads on your little four-wheeler. You get to do all that. Your rights are respected. That's why they were able to come to this decision. It's because the New Yorkers, them little Yorkies, went a little too hard. Between 2008 and 2017, Koch was in the same position as Nash. He faced no special dangers, wanted a handgun for general self-defense, and had only a restricted license permitting him to carry a handgun outside the home for hunting and target shooting. In late 2017, Koch applied to a licensing officer to remove the restrictions on his license, citing his extensive experience in safely handling firearms. Like Nash's application, Koch's was denied, except that the officer permitted Koch to carry to and from work. Respondents are the whenever I see the word superintendent, I always reflexively want to say Super Nintendo. Respondents are the superintendents of the New York State Police, who oversee the enforcement of the state's licensing laws, and a New York Supreme Court justice who oversees the processing of licensing applications in Rensselaer County. Petitioners sued respondents for declaratory and injunctive relief under New York law and federal law, alleging that respondents violating their Second and 14th Amendment rights by denying their unrestricted license applications on the basis that they had failed to show proper cause, i.e., they failed to demonstrate a unique need for self-defense. Can you guys just think about that for a second? A unique need for self-defense. What the hell is that? Does that mean you have a unusual life, right? Your life is oddly worth something? A unique need for self-defense. Think about how disgustingly just evil that is. Some people are more equal than others. The district court dismissed petitioner's complaint and the Court of Appeals affirmed. Both courts relied on the Court of Appeals' prior decision in Kachalski, which had sustained New York's proper cause standard, holding that the requirement was substantially related to the achievement of important government interest. That basically meaning that the state had taken the magical talisman of gun violence and went, ooh, gun violence, ooh. And then the court goes, ah! And then it just finds for whatever the government's asking for. Oh, is the audio too low? It's showing in my thing that it's -10, which is good. I can boost it if I need to. Need a response. Okay. Everyone else is saying it's fine, so turn up your speakers. Okay, wait. Smidge low. Let me boost it just a little bit. Boop. Okay. Yeah, supporting government interest. We granted certiorari to decide whether New York's denial of petitioners' license applications violated the Constitution. In Heller and McDonald, we held that the Second and 14th Amendments protect an individual right to keep and bear arms for self-defense. In doing so, we held unconstitutional 2 laws that prohibited the possession and use of handguns inside the home. For the years since, the Court of Appeals have coalesced around a around a 2-step framework for analyzing Second Amendment challenges that combines history with means-ends scrutiny. Today, we decline to adopt the 2-part approach. In keeping with Heller, we hold that when the Second Amendment's plain text covers an individual's conduct, the Constitution presumptively protects that conduct. Yes. I hate all these standards that they use. It's like, hey, does it say it? Yes. Okay, you can't do it, government. But let's see. I don't want to get too excited because they've got plenty of opportunity to cock it up. They got plenty of opportunity to muddle the waters, just like they did in Heller. So let's keep going. And actually, and Joshua, you're saying this won't end the special need part. I think they did it. I think that's what this does. So let's keep going. For analyzing, right? To justify this regulation, the government may not simply posit that the regulation promotes an important interest. Rather, the government must demonstrate that the regulation is consistent with this nation's historical tradition of firearms regulation. Only if a firearm regulation is consistent with this nation's historical tradition may a court conclude that the individual's conduct falls outside the Second Amendment's unqualified command. Okay, and then they cite Konigsberg. This is super concerning, right? Because this is kind of the test that a lot of boys on our side have been advocating for, the text, history, and tradition. The problem is, what is the history and tradition? The question is how recent they are willing to look at laws. Text, history, and tradition in other contexts has meant founding and early post-founding era stuff. The problem is whether they consider 1934 consistent with the nation's history and tradition. That would be a huge problem. We're going to find out here. So now we know the test is going to be text, history, and tradition. But how are they going to apply that here? This is actually kind of terrifying for me. Since Heller and McDonald, the 2-step test that the courts of appeals have developed to assess Second Amendment claims proceeds as follows. At the first step, the government may justify its regulation by establishing that the challenge law regulates activity falling outside the scope of the rights as originally understood. The Court of Appeals then ascertain the original scope of the right based on its historical meaning. If the government can prove that the regulated conduct falls beyond the amendment's original scope, then the analysis can stop there. The regulated activity is categorically unprotected. But if the historical evidence at this step is inconclusive or suggests that the regulated activity is not categorically unprotected, the courts generally proceed to step 2. And bear in mind, like, this is how they were applying it. And they were somehow, finding a lot of stuff without the scope of the Second Amendment. And if you guys watch my video on the canons, you'll see that there was not much stuff beyond the scope of Second Amendments, even up to 1899. At the second step, courts often analyze how close the law comes to the core of the Second Amendment right and the severity of the law's burden on that right. The Court of Appeals generally maintain that the core of the Second Amendment right is limited to self-defense in the home, which is a bunch of crap. If a core Second Amendment right is burdened, courts apply strict scrutiny and ask whether the government can prove that the law is narrowly tailored to achieve a compelling government interest. For those of you who don't know, rational basis means the government wins, strict scrutiny means the government loses, and intermediate means the government usually wins. Otherwise, they apply intermediate scrutiny and consider whether the government can show that the regulation is substantially related to the achievement of an important governmental interest. Both respondents and the United States largely agree with this consensus, arguing that intermediate scrutiny is appropriate when text and history are unclear in attempting to delineate the scope of that right. Despite the popularity of this 2-step approach, it is one step too many. Step 1 of the predominant framework is broadly consistent with Heller, which demands a test rooted in the Second Amendment's text, history, as informed by history. But Heller and McDonald do not support applying means and scrutiny in the Second Amendment context. Instead, the government must affirmatively prove that its firearms regulation is part of the historical tradition that delimits the outer bounds of the right to keep and bear arms. Which, again, like, look back at my Canon video. To show why Heller does not support applying means and scrutiny, we first summarize Heller's methodological approach to the Second Amendment. And also, I'm going to tell you guys, this is one of my unpopular opinions. I don't like Heller. I don't like the way Heller applied text, history, and tradition because it referred to presumptively lawful regulations which did not exist. It was a crap show. So let's see whether any of that is cured here. I know that Thomas had a problem with that. Let's see if Thomas was able to fix that here. To show why Heller does not support applying means and scrutiny, we first... Right. In Heller, we began with a textual analysis focused on the normal and ordinary meaning of the Second Amendment's language. That analysis suggested that the amendment's operative clause, the right of the people to keep and bear arms shall not be infringed, guarantees the individual right to possess and carry weapons in case of confrontation. That does not depend on service in the militia. From there, we assessed whether our initial conclusion was confirmed by the historical background of the Second Amendment. We look to history because it has always been widely understood that the Second Amendment was codifying a pre-existing right. The amendment was not intended to lay down a novel principle, but rather codified a right inherited from our English ancestors. After surveying English history dating from the late 1600s, along with American colonial views leading up to the founding, we found no doubt, on the basis of both text and history, that the Second Amendment conferred an individual right to keep and bear arms. We then canvassed the historical record and found yet further confirmation. That history included the analogous arms-bearing rights in state constitutions that preceded and immediately followed adoption of the Second Amendment, and how the Second Amendment was interpreted from immediately after its ratification through the end of the 19th century. When the principal dissent charged that the latter category of sources was illegitimate post-enactment legislative history, we clarified that examination of a variety of legal and other sources to determine the public understanding of a legal text in the period after its enactment or ratification was a critical tool of constitutional interpretation. So that's them responding to people who were like, oh, no, you went beyond the thing. You got right. In assessing the post-ratification history, we looked to 4 different types of sources. First, we reviewed 3 important founding-era legal scholars who interpreted the Second Amendment in published writings. Second, we looked to 19th century cases that interpreted the Second Amendment and found that they universally support an individual right to keep and bear arms. Third, we examined the discussion of the Second Amendment in Congress and in public discourse after the Civil War as people debated whether and how to secure constitutional rights for newly freed slaves. Fourth, we considered how post-Civil War commentators understood the right. After holding that the Second Amendment protected an individual right to armed self-defense, we also relied on the historical understanding of the amendment to demark what limits on the exercise of the right. We noted that, like most rights, the right secured by the Second Amendment is not unlimited. From Blackstone through the 19th century cases, commentators and courts routinely explained that the right was not a right to keep and carry any weapon whatsoever in any manner whatsoever and for whatever purpose. For example, we found it fairly supported by the historical tradition of prohibiting the carrying of dangerous and unusual weapons that the Second Amendment protects the possession and use of weapons that are in common use at the time. That was total BS. There was no such thing as dangerous and unusual weapons. It was total BS. It was a bunch of crap. That said, we cautioned that we were not undertaking an exhaustive historical analysis today of the full scope of the Second Amendment and moved on to considering the constitutionality of the District of Columbia's handgun ban. We assessed the lawfulness of that handgun ban by scrutinizing whether it comported with history and tradition. Although we noted that the ban would fail constitutional muster under any of the standards of scrutiny that we have applied to enumerated constitutional rights, we did not engage in means-end scrutiny when resolving the constitutional question. Instead, we focused on the historically unprecedented nature of the district's ban, observing that few laws in the history of our nation have come close to that severe restriction. Likewise, when one of the dissents attempted to justify the district's prohibition with founding-era historical precedent, including various restricting laws in the colonial period, we addressed each purported analog and concluded that they were either irrelevant or did not remotely burden the rights of self-defense as much as an absolute ban on handguns. Thus, our earlier historical analysis sufficed to show that the Second Amendment did not countenance a complete prohibition on the use of the most popular weapon chosen by Americans for self-defense in the home. Yeah, no, you guys are right. It does not say what arms. It does not. Like, I have a huge problem with the dangerous and unusual idea, because arms are dangerous. That's like their point. So does that just mean that rare or newly introduced arms are prohibitable? Well, that's completely inconsistent with the text, history, and tradition of the Second Amendment. I wish they would have just ditched that element of Heller, because that component of Heller is junk. As the foregoing shows, Heller's methodology centered on constitutional... Thank you, Scott Campos. Thank you for the super deluxe chat. Thank you, Matt, for being smarter than I am. Appreciate what you do for the 2A community. I'm actually really stupid. I'm actually kind of a idiot. But thank you for the super chat. Heller relied on text and history. It did not invoke any means and test, such as strict or intermediate scrutiny. Moreover, Heller and MacDonald expressly rejected the application of any judge-empowering interest-balancing inquiry that asks whether the statute burdens a protected interest in a way or to an extent that is out of proportion to the statute's salutary effects upon other important governmental interests. This is the worst thing about legal writing, is the extent of... And this is what makes it hard for non-lawyers to read an opinion, is the extent of in-text citations, right? It just like shits up the entire thing. We declined to engage in means-ends scrutiny because the very enumeration of the right takes out of the hands of the government, even the third branch of government, the power to decide on a case-by-case basis whether the right is really worth insisting upon. We then concluded a constitutional guarantee subject to future judges' assessments of its usefulness is no constitutional guarantee at all. That was good language. Not only did Heller decline to engage in means-end scrutiny generally, but it also specifically ruled out the intermediate scrutiny test that respondents in the United States now urge us to adopt. Dissenting in Heller, Justice Breyer's proposed standard, asking whether a statute burdens a protected interest in a way or to an extent that is out of proportion to the statute's salutary effects upon other important governmental interests, simply expressed a classic formulation of intermediate scrutiny in a slightly different way. In fact, Justice Breyer all but admitted that his Heller dissent advocated for intermediate scrutiny by repeatedly invoking a quintessential intermediate scrutiny precedent. Thus, when Heller expressly rejected that dissent's interest-balancing inquiry, it necessarily rejected intermediate scrutiny. So this is pretty big so far. He hasn't assessed a standard for dealing with those edge cases. But they are saying that if it implicates Second Amendment conduct, it's out. The only question is how they're going to mete out Second Amendment conduct, because the way they meted it in Heller was bad. All right. In sum, the Court of Appeal's second step is inconsistent with Heller's historical approach. Thank you, Nitrace. He said it's a based live stream. I wonder if that's true. With Heller's historical approach and its rejection of means-end scrutiny, we reiterate that the standard for applying the Second Amendment is as follows. When the Second Amendment's plain text covers an individual's conduct, the Constitution presumptively protects that conduct. The government must then justify its regulation by demonstrating that its regulation is consistent with the nation's historical tradition of firearm regulation. Only then may a court conclude that the individual's conduct falls outside the Second Amendment's unqualified command. Okay, so all of the fighting is going to be on that text, history, and tradition. And also, looks like the burden is now on the government, right? So that's pretty big. That's pretty big. Oh, you just said Heller wasn't sufficient. The live stream's extremely base. Heller wasn't sufficient. It was crap. And I mean, I actually kind of, there's one component of Breyer's dissent that was dead true. In that, in Heller, the majority did not announce a standard. It merely invented crap that it thought was reasonable, and that was true. When they sat there and they were saying the M16 rifles and the like dangerous and unusual prohibitions on felons, it was a bunch of crap. Because guess what? Prohibitions on felons, that's not real. All the stuff from going back to the early founding era, people who were convicted of like treason could have their arms restored in very short order, and oftentimes automatically had their arms returned to them after a couple of years. So they just made a bunch of crap up in Heller. It was just a bunch of crap. I'm sorry. It was wrong. Anyway, the Second Amendment standards accords with how we protect other constitutional rights. Take, for instance, the freedom of speech in the First Amendment, to which Heller repeatedly compared the right to keep and bear arms. In that context, when the government restricts speech, the government bears the burden of proving the constitutionality of its actions. In some cases, that burden includes showing whether the expressive conduct falls outside the category of protected speech. And to carry that burden, the government must generally point to historical evidence about the reach of the First Amendment's protections. And so this is talking about, you know, stuff that's outside of the First Amendment speech. They're talking about obscenity. They're talking about true threats. Let me look at the comments here. No, tofu is bad. It's bad for you. Guys, don't eat soy. And that's not like a political statement. Don't eat soy. It's bad for your thyroid. And beyond the freedom of speech, our focus on history also comports with how we assess many other constitutional claims. If a litigant asserts the right in court to be confronted with the witnesses against him, we require the courts to consult history to determine the scope of that right. Similarly, when a litigant claims a violation of his rights under the Establishment Clause, members of this court look to history for guidance. We adopt a similar approach here. To be sure, historical analysis can be difficult. It sometimes requires resolving threshold questions and making nuanced judgments about which evidence to consult and how to interpret it. But reliance on history to inform the meaning of constitutional text, especially text meant to codify a pre-existing right, is, in our view, more legitimate and more administratable than asking judges to make difficult empirical judgments about the costs and benefits of firearms restrictions, especially given their lack of expertise in the field. Yeah, did you know that judges are just lawyers in dresses? And did you know that lawyers are dumb and bad? If the last decade of Second Amendment litigation has taught this court anything, it is that the federal court tasked with making such difficult empirical judgments regarding firearm regulations under the banner of intermediate scrutiny often defer to the determinations of the legislatures. Shocker. But while that judicial deference to legislative interest balancing is understandable and elsewhere appropriate, it is not deference that the Constitution demands here. Second Amendment is the very product of an interest balancing by the people, and it surely elevates above all other interests the right of law-abiding, responsible citizens to use arms for self-defense. It is this balance, struck by the traditions of the American people, that demands our unqualified deference. All right, Sig Kill. I've told the shyster lawyer Rakita to have you on tonight. I super chatted him a while back asking why he ghosted you and said it was because Deb heard case. Oh, well. Thank you for the super chat. I super appreciate it. So yeah, what are they saying here? This is actually pretty big. Deference, right? Interest balancing. They're saying what has happened before up to this point is that all of the courts below were asking the government is, okay, sell us on this law. Why'd you pass it? And they'd be like, oh, because everybody saw you. We were really scared, and they were gonna save the lives. And they go, oh, you're gonna save the lives? That's pretty big, right? And that was all they would do. Rights don't work like that, and that's kind of what he's getting at here. You don't get to just explain away a right. That's not how a right works. I'm just still, I have extreme trepidation about how we're going to go forward here, how the rest of this is going to go, whether he's going to attempt to re-justify some of Scalia's unreasoning in Heller. So let's just keep going. He doesn't have to, by the way. He doesn't have to do that. And Thomas knows brevity. Thomas knows that he doesn't need to do that. Oh, also, thank you, Night Trace, for bringing that up. Because you know what I wanted to mention here? What do you guys see in this sentence that is not in the Second Amendment? And yeah, Night Trace says, wonder when we can revisit why felons aren't allowed to be humans after they've served their sentences. That's a big one. So yeah, what in this sentence is not part of the Second Amendment? And I know I'm gonna tick some of you off, but I'm okay with you. I'm okay with that. There's a word here. There's a limiting word. And this is important. No, guys. Citizens. Show me in the Second Amendment where it says the word citizens. Show me. It doesn't. It does not say citizens. It is the right of the people to keep and bear arms. And people will say, oh, no, citizens don't have constitutional protections. BS, because guess what? The word citizen is in the Constitution once. And it is referred to as just like it's like a nothing burger administrative thing. They knew the word citizen. And there was a distinction. They knew the word citizen. People have rights. Citizen is a BS paper trail nonsense garbage thing that nobody cared about in this country until the past few decades. And that crap really gets me up. Crap really gets me up. Because who most needs a right to protect themselves? People who are subject to danger. Who is subject to danger? People who are lower income. Who are lower income? A lot of the people who come here to work their butts off. And I've seen it happen. You know, I'm a Floridian. I've worked with a lot of, people, migrant laborers who live in a hard side of town. Guess what? They're screwed. That's immoral. It's freaking immoral. The test we set forth in Heller and apply today requires courts to assess whether modern firearms regulations are consistent with the Second Amendment's text and historical understanding. In some cases, that inquiry will be fairly straightforward. For instance, when a challenge regulation addresses a general societal problem that has persisted since the 18th century, the lack of a distinctly similar historical regulation addressing that problem is relevant evidence that the challenge regulation is inconsistent with the Second Amendment. Damn. Likewise, if earlier generations addressed the societal problem but did so through materially different means, that could also evidence that a modern regulation is unconstitutional. And if some jurisdictions actually attempted to enact analogous regulations during this time frame, but those proposals were rejected on constitutional grounds, that rejection surely would provide some probative evidence of unconstitutionality. I just want to read how you guys are. Just wanted to read the comments real quick. Damn, we got a few of you on here. That's pretty good. We got a few people here. All right, let's keep going. Heller itself exemplifies this kind of straightforward historical inquiry. One of the district's regulations challenged in Heller totally banned handgun possession in the home. The district in Heller addressed a perceived societal problem. Oh, I like how they put in that word, perceived. Perceived societal problem. Firearm violence in densely populated communities. And it employed a regulation, a flat ban on the possession of handguns in the home, that the founders themselves could have adopted to confront that problem. Accordingly, after considering founding-era historical precedent, including various restrictive laws in the colonial period, and finding that none was analogous to the district's ban, Heller concluded that the handgun ban was unconstitutional. Let me also bring something else up here that I don't like about the way they approach this. We're talking about the Second Amendment. The Second Amendment was not incorporated against the states until the 14th Amendment was passed. And so there was a lot of laws, right, at the time, because the states had their own constitutionals. They were not required to follow the Second Amendment. So some of this crap, when they bring up the like historical laws, like in like Virginia colonies and stuff like that, like, whoa, hold on, right? Hold on. I get the argument, right, that they're suggesting that if it was understood as a pre-existing English common law right, that it couldn't have been done. But tyranny of the majority, especially in terms of smaller majorities, is a huge problem. Right. So after considering founding-era historical precedent, including various restrictive laws in the colonial period, and finding that none was analogous to the district's ban, Heller concluded that the handgun ban was unconstitutional. New York's proper cause requirement concerns the same alleged societal problem addressed in Heller's, handgun violence, primarily in urban areas. Following the course started by Heller, we will consider whether historical precedent from before, during, and even after the founding evinces a comparable tradition of regulation. And, as we explain below, we find no such tradition in the historical materials that respondents and their amici have brought to bear on that questions. I also just think it's pretty big that Thomas, like, such a good writer, he doesn't like, P. Jackie. Somebody give him an interview to one of my British a link to one of my British interviews. He uses the word evince and evidence in like the transitive sense in within a page of each other. That's big boy writing energy right there. New York's proper cause requirement concerns the same alleged societal problem. Right. While the historical analogies here and in Heller are relatively simple to draw, other cases implicating unprecedented societal concerns or dramatic technological changes may require a more nuanced approach. The regulatory challenges posed by firearms today are not always the same as those that preoccupied the founders in 1791 or the Reconstruction generation in 1868. Fortunately, the founders created a constitution and a Second Amendment intended to endure for ages to come and consequently to be adapted to the various crises of human affairs. Although its meaning is fixed according to the understandings of those who ratified it, the Constitution can and must apply to circumstances beyond those the founders specifically anticipated. We have already recognized in Heller at least one way in which the Second Amendment's historically fixed meaning applies to new circumstances. Its reference to arms does not apply only to those arms in existence at the 18th century. Just as the First Amendment protects modern forms of communications and the Fourth Amendment applies to modern forms of search. The Second Amendment extends prima facie, that means on its face, to all instruments that constitute bearable arms, even those that were not in existence at the time of the founding. Thus, even though the Second Amendment's definition of arms is fixed according to its historical understanding, that general definition covers modern instruments that facilitates armed self-defense. Much like we use history to determine which modern arms are protected by the Second Amendment, so too does history guide our consideration of modern regulations that were unimaginable at the founding. When confronting such present-day firearm regulations, this historical inquiry that courts must conduct will often involve reasoning by analogy, a commonplace task for any lawyer or judge. Like all analogical reasoning, Determining whether a historical regulation is a proper analog for a distinctly modern firearm regulation requires a determination of whether the two regulations are relatively similar. So they're kind of sitting here like talking about how you would superimpose the historical restriction upon the one that the government is trying to put up right now. Nitrace makes a good point. Historically, gun control laws were specifically designed to harm workers and people of color. Same with pigs. Curious. Anyway. Relatively similar. For instance, a green truck and a green hat are relatively similar if one's metric is things that are green. They are not relatively similar if the applicable metric is things you can wear. That's pretty good. While we do not now provide an exhaustive survey of the features that render regulations relevantly similar under the Second Amendment, we do think that Heller and McDonald point toward at least two metrics. So this is where I'm getting nervous. How and why the regulations burden a law-abiding citizen's right to armed self-defense. As we stated in Heller and repeated in McDonald, individual self-defense is the central component of the Second Amendment right. Therefore, whether modern and historical regulations impose a comparable burden on the right of armed self-defense and whether that burden is comparatively justified are central considerations when engaging in an analogical inquiry. To be clear, analogical reasoning under the Second Amendment is neither a regulatory straitjacket nor a regulatory blank check. On the one hand, courts should not uphold every modern law that remotely resembles a historical analog, because doing so risks endorsing outliers that our ancestors would have never accepted. On the other hand, analogical reasoning requires only that the government identify a well-established and representative historical analog, not a historical twin. So even if a modern-day regulation is not a dead ringer for historical precursors, it still may be analogous enough to pass constitutional muster. Hey, hold on. Matt, you will love BBC reports on 3D firearms in the UK. The UK police is pissing its pants. Also enjoy my currency to buy more tea to throw away. Damn. He sent me British pounds. What am I going to buy with that? Maybe a scone. Thanks for the scone money. Consider, for example, Heller's discussion of long-standing laws forbidding the carrying of firearms in sensitive places such as schools and government buildings. Although the historical record yields relatively few 18th and 19th century sensitive places where weapons were altogether prohibited, example, legislative assemblies, polling places, and courthouses, they were not prohibited there. We are also aware of no disputes regarding the lawfulness of such prohibitions. Hey, Joe Greenlee got cited. That's my homie. David Copeland Greenlee. He's such an amazing writer. We therefore assume it settled that these locations were sensitive places when arms carrying could... Wait, why are they deciding that? Wait, why are you... Why? Why are you saying that it's okay to restrict carrying of arms in these places? That's not what this case is about. Okay, little mad. Thank you, OP, for talking. He's gotten turgid from a supple voice. Wonderful. Yeah, no, that's I'm kind of mad right now. We therefore can assume it's settled that these locations were sensitive places where arms carrying could be prohibited consistent with the Second Amendment. That's kind of BS. And courts can use analogies to those historical regulations of sensitive places to determine that modern regulations prohibiting the carry firearms in new and analogous sensitive places are constitutionally permissible. Although we have no occasion to comprehensively define sensitive places in this case, although you just kind of did, you weirdo, we do think respondents err in their attempts to characterize New York's proper cause requirement as a sensitive place law. Yeah, New York is a sensitive place, right? Vin saying, by saying that, does this open the door to them to tack more places onto the list of sensitive places? Yes, it does. That is going to be, and they're going to be scooping on that thing. They're going to be like, oh, look, see, he said we can do it. Oh, look, we just have to say it's just like that. So I don't know why he did that. I guess he wanted to have one example, but he could have said perhaps. Like, he didn't have to decide it there. I mean, it is kind of dictum. Yeah, I can't wait to get to Kavanaugh's concurrence. Does it really suck? Lone Wolf just did a super chat. Said, we need a pro 2A lawyer association that will help raise baby lawyers into 2A advocates. All associations of lawyers are bad ideas. Right. So, yeah, basically, trying to say New York is a sensitive place. In their view, New York's view, sensitive places where the government may lawfully disarm law-abiding citizens include all places where people typically congregate and where law enforcement and other public safety professionals are presumptively available. Okay. It is true that people sometimes congregate in sensitive places, and it is likewise true that law enforcement professionals are usually presumptively available in those locations. Yeah, anywhere you go, there's going to be a cop willing to break your spine for no reason. Like, they're always available. Just a call away. I've got a spine. It's intact. Come here, officer. Can you fix it? But expanding the category of sensitive places simply to all places of public congregation that are not isolated from law enforcement defines the category of sensitive places far too broadly. I would like to expand the amount of places that are isolated from law enforcement. What do you guys think? I think that would be pretty big. Respondents' argument would in effect exempt cities from the Second Amendment and would eviscerate the general right to publicly carry arms for self-defense that we discuss in detail below. Oh, that's part 3 where they're going to talk about the specific carry right. Yeah, that's going to be pretty good. Put simply, there is no historical basis for New York to effectively declare the island of Manhattan a sensitive place simply because it is crowded and protected generally by the New York City Police Department. The word protected is very interesting there. Like Heller, we do not undertake an exhaustive historical analysis of the full scope of the Second Amendment, and we acknowledge that applying constitutional principles to novel, modern conditions can be difficult and leave close questions at the margins. But that is hardly unique to the Second Amendment. It is an essential component of judicial decision-making under our enduring Constitution. We see no reason why judges frequently tasked with answering these kinds of historical analogical questions cannot do the same for Second Amendment claims. Having made the constitutional standard endorsed in Heller more explicit, we now apply that standard to New York's proper cause requirement. All right, so I'm hoping we're out of the woods. I'm hoping there's not going to be more general applicable language that could cock us up in the future. I think we might be there. We might be out of the woods. All right, so here we go. It is undisputed that petitioners Koch and Nash, 2 ordinary law-abiding adult citizens. It's bad that every time I read the word who wrote this? Kindergartners, they got no vision. Thank you, OP. I just figured out who you were because of your image. That's my buddy. That's my Gino. What was I just saying? God, whatever. Oh yeah, every time I see the word citizen, I get a little triggered. It's like, you little, show me where it says that. Show me. I'll give you $1,000. Show me where it says that. Yeah, and Vin says, places where law enforcement is available when it is understood that the police are not obligated to protect or rescue you. Am I having an audio problem now? Okay. Sweet. Okay, now I have dogs. Great. Hey, shut up, dog. Hey, shut up. Come here. Come here. Come here. If I hold you, you'll stop barking. Puppy stream. All right. We have, nor does any party dispute that the handguns are weapons in common use today for self-defense. We therefore turn to whether the plain text of the Second Amendment protects Koch's and Natch's proposed course of conduct carrying handguns publicly for self-defense. We have little difficulty concluding that it does. Respondents do not dispute this, nor could they, Nothing in the Second Amendment's text draws a home public distinction with respect to the right to keep and bear arms. As we explained in Heller, the textual elements of the Second Amendment's operative clause, the right of the people to keep and bear arms shall not be infringed, guarantee the individual right and to possess and carry weapons in case of confrontation. Heller further confirmed that the right to bear arms refers to the right to wear, bear, or carry upon the person or in the clothing or in a pocket for the purpose of being armed and ready for offensive or defensive action in a case of conflict with another person. Why do they hinge so much on law enforcement being an appropriate remedy when they also say law enforcement doesn't have to help you? More British pounds for ammo. Thank you. Enjoy your rights. I talked to some UK shooters that say that Cali gun rights are better than UK laws. I mean, I don't know. But yeah, no. So the law enforcement thing is because it's So there are some doctrines of substitution, right? Because if the law is about self-defense, there's like an argument that can be made that if like they had hyper turbo cops, that completely supplanted your need for self-defense, that it like weakens it. I don't think that's a real theory, but it's one that has been advanced, and so I think that they are addressing there. Because remember, they were addressing the government's argument in that paragraph. Nothing in the minute. Public place decision. The definition of bear naturally encompasses public carry, which we've been saying forever, boys. That's what we've been saying. Most gun owners do not wear a holstered pistol at their hip in the bedroom or while sitting at the dinner table. Although individuals often keep firearms in their home at the ready for self-defense, most do not bear them in the home beyond moments of actual confrontation. To confine the right to bear arms to the home would nullify half of the Second Amendment's operative protections. That's a pretty interesting logical argument. Yeah, don't think about that, what they're saying. That would mean that if you only have the right to have an arm in the home, it would be like, what's the distinction between keep and bear? I think that the keep and bear distinction is different. I think that there are types of arms that are bearable that you can bear, right, in your arms. And then I think that there are arms that are not quite as bearable, which are cannons, ATGMs, AMX-13 light tanks. I think those are the types of arms that are kept. But anyway, let's keep going. Moreover, confining the right to bear arms to the home would make little sense, given that self-defense is the central component of the Second Amendment right itself. After all, the Second Amendment guarantees an individual right to possess and carry weapons in case of confrontation, and confrontation can surely take place outside the home. In fact, that's where it usually happens. Although we remarked in Heller that the need for armed self-defense is perhaps most acute in the home, we did not suggest that the need was insignificant elsewhere. Many Americans hazard greater danger outside the home than in it. Chicagoan is a good deal more likely to be attacked on a sidewalk in a rough neighborhood than in his apartment on the 35th floor of Park Tower. It's funny. The text of the Second Amendment reflects that reality. The Second Amendment's plain text thus presumptively guarantees Petitioner Koch and Nash a right to bear arms in public for self-defense. Conceding that the Second Amendment guarantees a general right to public carry, respondents instead claim that that's where they contra Young, which was like, there is no right to so they're kind of like pissing on the Young case. Respondents instead claim that the amendment permits a state to condition handgun carrying in areas frequented by the general public on a showing of non-speculative need for armed self-defense in those areas. To support that claim, the burden falls on respondents, the government, to show that New York's proper cause requirement is consistent with the nation's historical tradition of firearm regulation. Only if respondents carry that burden can they show that the pre-existing right codified in the Second Amendment and as made applicable to the states through the 14th does not protect petitioners' proposed course of conduct, that being to carry a gun in public. 1 second, let me just check my messages here. As you guys can probably imagine, I'm getting a lot of buzzing. Let's check out the PR. Open that. Whoops. Okay. Where were we? Respondents appeal to a variety of... What are you guys saying? Here's for specific... I personally own a papered claymore. This could get interesting. Talking about upstate New York. All right. Respondents appeal to a variety of historical resources from the late 1200s to the early 1900s. We categorize these periods as follows. 1. Medieval to early modern England. 2. The American colonies in the early Republic. 3. Antebellum America. 4. Reconstruction. And 5. The late 19th and early 20th centuries. We categorize these historical sources because when it comes to interpreting the Constitution, not all history is created equal. Constitutional rights are enshrined with the people with the scope they were understood to have when the people adopted them. So, okay, what he's saying there is actually pretty good. I like where he's going. Let's see if he, craps it up. Second Amendment was adopted in 1791, the 14th in 1868. Historical evidence that long predates either date may not illuminate the scope of the right if linguistic or legal conventions changed in the intervening years. It is one thing for courts to reach back to the 14th century for English practices that prevailed up to the period immediately before and after the framing of the Constitution. It is quite another to rely on ancient practice that had become obsolete in England at the time of the adoption of the Constitution and never was acted upon or accepted in the colonies. Okay, so the thing we have to be worried about here is the 14th Amendment era stuff, because there were some states that were up to some no good Nick behavior at that time. As with historical evidence, generally, courts must be careful when assessing evidence concerning English common law rights. The common law, of course, developed over time, and English common law practices and understandings at any given time in history cannot be indiscriminately attributed to the framers of our own Constitution. Even the words of the Magna Carta, foundational as they were to the rights of America's forefathers, stood for very different things at the time of the separation of the American colonies from what they represented originally in 1215. Sometimes, in interpreting our own Constitution, it is better not to go too far back into antiquity for the best securities of our liberties. Unless evidence shows that medieval law survived to become our founders' law. A long, unbroken line of common law precedent stretching back from Bracton to Blackstone is far more likely to be part of our law than a short-lived 14th century English practice. Similarly, we must also guard against giving post-enactment history more weight than it can rightly bear. It is true that in Heller we reiterated that evidence of how the Second Amendment was interpreted from immediately after the ratification through the end of the 19th century represented a critical tool of constitutional interpretation. We therefore examined a variety of legal and other sources to determine the public understanding of the Second Amendment after its ratification. And in other contexts, we have explained that a regular course of practice can liquidate and settle the meaning of disputed or indeterminate terms and phrases in the Constitution. Oh, wow. In other words, we recognize that where a governmental practice has been obeyed, widespread, and unchallenged since the early days of the Republic, the practice should guide our interpretation of an ambiguous constitutional provision. But to the extent later history contradicts what the text says, the text controls. Liquidating indeterminacies in written laws is far removed from expanding or altering them. Thus, post-ratification adoption or acceptance of laws that are inconsistent with the original meaning of the constitutional text obviously cannot overcome or alter that text. Makes sense? Simple statement of principle. As we recognized in Heller itself, because post-Civil War discussions of the right to keep and bear arms took place 75 years after the ratification of the Second Amendment, they do not provide as much insight into its original meaning as earlier sources. And we made clear in Gamble that Heller's interest in mid to late 19th century commentary was secondary. Heller considered this evidence only after surveying what it regarded as a wealth of authority for its reading, including the text of the Second Amendment and state constitution. In other words, this 19th century evidence was treated as mere confirmation of what the court thought had already been established. A final word on historical method. Strictly speaking, New York is bound to respect the right to keep and bear arms because of the 14th Amendment, not the Second. Nonetheless, we have made clear that individual rights enumerated in the Bill of Rights and made applicable against the states through the 14th Amendment have the same scope as against the federal government. Which, I don't understand why ratification periods would then... Yeah, I don't know, that's odd. Professors, I'm reading this as a direct line for challenging the constitutionality of the NFA-GCA Hughes Amendment. They can't survive under this holding. We haven't finished reading the holding, Jim. We haven't finished. There may be some poison in here. A final word on historical method. Strictly speaking, New York is bound to respect the right to keep and bear arms because of the 14th Amendment. And not the Second. Nonetheless, we have made clear that individual rights enumerated in the Bill of Rights and made applicable against the state the government have the same scope as against the federal government, and we have generally assumed that the scope of the protections applicable to the federal government and states is pegged to the public understanding of the right when the Bill of Rights was adopted in 1791. One second. Captain Bard, possible springboard for reciprocity. New York doesn't have a non-resident parent system, but my constitutional rights should not end at their border. I don't think that this goes directly to reciprocity. Reciprocity is a very different problem, especially constitutionally. And if we're... Thank you. Yes, I do type a little fast. Your boy can type. Sorry, boys. It's a... You guys know why it sounds like that? I got the real stuff. I got the good. All right, let's keep it going. Yeah, I got the real keyboard. This a 86. Yeah. All right. We also acknowledge that there is an ongoing scholarly debate on whether courts should primarily rely on the prevailing understanding of an individual right when the 14th Amendment was ratified in 1868 when defining its scopes. Yeah, see, this is a problem. We need not address this issue today because, as we explained below, the public understanding of the right to keep and bear arms in both 1791 and 1868 was, for all relevant purposes, the same with respect to public carry. With these principles in mind, we turn to respondents' historical evidence. The government, they're turning to what the government has put before the court. Oh yeah, no, this is a 1986 keyboard. It is a pre-band. Yeah, it's a transferable. All right. With these principles in mind, we turn to respondents' historical evidence. Throughout modern Anglo-American history, the right to keep and bear arms in publics has traditionally been subject to well-defined restrictions governing the intent for which one could carry arms, the manner of carry, or the exceptional circumstances on which one could not carry arms. But apart from a handful of late 19th century jurisdictions, the historical record compiled by the government does not demonstrate a tradition of broadly prohibiting the public carry of commonly used firearms for self-defense. So wait, what do they actually... Throughout modern... Rollers has traditionally been subject to well-refined restrictions governing the intent for which one, manner, and exceptional. Okay, interesting is what they're recognized there. Hey, David, yeah, it is his birthday. Sorry about that, guys. Getting a lot of messages. Nor is there any such historical tradition limiting public carry only to those law-abiding citizens who demonstrate a special need for self-defense. We conclude that respondents have failed to meet their burden to identify an American tradition justifying New York's proper cause requirement. Under Heller's text and history standard, the proper cause requirement is therefore unconstitutional. Damn. He got straight to it. Look at that. Boop. There's the application. You didn't find anything. So the government's substantial reliance on English history and custom before the founding makes some sense given our statement in Heller that the Second Amendment codified a right inherited from our English ancestors. But this court has long cautioned that the English common law is not to be taken in all respects to be that of America. Thus, the language of the Constitution cannot be interpreted safely except by reference to the common law and to British institutions as they were when the instrument was framed and adopted, not as they existed in the Middle Ages. We interpret the English history that respondents in the United States muster in light of these interpretive principles. We find that history ambiguous, and at best, we find that history ambiguous at best, and see little reason to think that the framers would have thought it applicable to the New World. It is not sufficiently probative to defend New York's proper cause requirement. And of course, they're talking about here. This is actually what I talked about in my last video. Well, not my last video, in the canon one. They're talking about these like feudal, like arms restrictions that existed, in that post-medieval period where, you could only have a weapon if the king was had called you a very good boy. Mm-hmm. Yeah. To begin, respondents and their amici point to several medieval English regulations from as early as 1285 that they say indicate a long-standing tradition of restricting the public carry of firearms. The most prominent is the 1328 Statute of Northampton. Oh my God, they bring it up all the time. Passed shortly after Edward II was deposed by force of arms, and his son, Edward III, took the throne of a kingdom where tendency to turmoil and rebellion was everywhere apparent throughout the nation. At the time, bands of malefactors, knights as well as those of a lesser degree, harried the country, committing assaults and murders, prompted by a more general spirit of insubordination that led to a decay in English national life. So yeah, it's safe to say it was just a bit different at the time of the Statute of Northampton. And especially because the new king was like, y'all just like stabbed my dad a lot. I think I'm gonna not want to get stabbed. So yeah, the Statute of Northampton was in part a product of the acute disorder that still plagued England. Imagine being English. It provided that, with some exceptions, Englishmen could not come before the king's justices or others of the king's ministers doing their offices with force and arms, nor bring no force in a fray of the peace, nor go nor ride armed by night nor by day in fairs, markets, nor in the presence of the justices or other ministers, nor in no part elsewhere upon pain to forfeit their armor to the king, and their bodies to prison and the king's pleasure. God, imagine. At the king's pleasure. Respondents argue that the prohibition on riding or going armed was a sweeping restrictions on public carry of self-defense weapons that would ultimately be adopted in colonial America and justify onerous public carry regulations. Notwithstanding the ink the parties spill over this provision, the Statute of Northampton, at least as it was understood during the Middle Ages, has little bearing on the Second Amendment adopted in 1791. The Statute of Northampton was enacted nearly 20 years before the Black Death, more than 200 years before the birth of Shakespeare, more than 350 years before the Salem witch trials, more than 450 years before the ratification of the Constitution, and nearly 550 years before the adoption of the 14th Amendment. The statute's prohibition on going or riding armed obviously did not contemplate handguns, given they did not appear in Europe until about the mid-1500s. Rather, it appears to have been centrally concerned with the wearing of armor. If it did apply beyond armor, it applied to such weapons as the lance, a 10-foot to 12-foot long lightweight lance. The statute's apparent focus on armor and perhaps weapons like lances makes sense given that armor and lances were generally worn or carried only when one intended to engage in lawful combat, or as most early violations of the statute show, to breach the peace. Contrast these arms with daggers. In the medieval period, almost everyone carried a knife or a dagger in his belt. While these knives were used by knights in warfare, civilians wore them for self-protection, among other things. Respondents point to no evidence suggesting the statute applied to the smaller medieval weapons that strike us as most analogous to modern handguns. When handguns were introduced in England during the Tudor and early Stuart eras, they did prompt royal efforts at suppression. For example, Henry VIII issued several... Henry VIII, isn't he just a wonderful boy? Imagine being the government and trying to rely on Henry VIII. Imagine being the government. So, yeah. For example, Henry VIII issued several proclamations decrying the proliferation of handguns, and Parliament passed several statutes restricting their possession. But Henry VIII's displeasure with handguns arose not primarily from concerns about their safety, but rather their inefficacy. Henry VIII warned that handguns threatened Englishmen's proficiency with the longbow, a weapon many believed was crucial to the English. A weapon which Henry VIII believed was crucial to English military victories in the 13 and 1400s, including the legendary English victories at Crécy and Agincourt. Since similarly, James I considered small handguns called dags. Can we bring that back? Can we bring back the dag? I want to carry a dag. Utterly unsurfaceable for defense, military practice, or other lawful use. Yeah, I want a dag. I want an utterly unsurfaceable dag. That sounds cool. Pocket dags. But in any event, James I's proclamation in 1616 was the last one regarding civilians carrying dags. He was literally like, those are bad. And that was it. After this, the question faded without explanation. Without explanation. So by the time Englishmen began to arrive in America in the early 1600s, the public carry of handguns was no longer widely prescribed. When we look to the latter half of the 17th century, respondents' cases only weakens. As in Heller, we consider this history between the Stuart Restoration in 1660 and the Glorious Revolution in 1688 to be particularly instructive. During that time, the Stuart kings Charles II and James II rammed up efforts to disarm their political opponents, an experience that caused Englishmen to be jealous of their arms. In one notable example, the government charged Sir John Knight, a prominent detractor of James II, with violating the Statute of Northampton because he allegedly did walk about the streets armed with guns, and that he went into the Church of St. Michael in Bristol in the time of divine service with a gun to terrify the king's subjects. based, meaning that the statute had largely become obsolete through disuse. And the Chief Justice further explained that the act of going armed to terrify the king's subject was a great offense at the common law, and that the Statute of Northampton is but an affirmance of that law. Thus, one conduct will come within the act, i.e., it would terrify the king's subjects, only where the crime shall appear to be malo animo, with evil intent or malice. Knight was ultimately acquitted by the jury. Womp womp. Henry VIII, the original Fudd. It's funny. Just 3 years later, Parliament responded by writing the predecessor to our Second Amendment into the 1689 English Bill of Rights. How'd that go for you guys? Guaranteeing that Protestants may have arms for their defense, suitable to their conditions, and as allowed by law. Although this right was originally limited, it was restricted to Protestants and held only against the crown, but not Parliament. It represented a watershed in English history. Englishmen had never before claimed the right of the individual to bear arms. And as that individual right matured, by the time of the founding, the right to keep and bear arms was understood to be an individual right to protect against both public and private violence. To be sure, the Statute of Northampton survived both Sir John Knight's case and the English Bill of Rights, but it was no obstacle to public carry for self-defense in the decades leading to the founding. Sergeant William Hawkins, in his widely read 1716 treatise, confirmed that no wearing of arms is within the meaning of the Statute of Northampton unless it be accompanied with such circumstances as are apt to terrify the people. Right? So just carrying of guns was not considered a prohibited act under the Statute of Northampton at that time, unless you were being a bad person. Going about trying to do a terror. To illustrate that proposition, Hawkins noted as an example that persons of quality, were in no danger of offending against this statute by wearing common weapons, because in those circumstances it would be clear that they had no intention to commit any act of violence or disturbance of the peace. Respondents do not offer any evidence showing that in the early 18th century or after, the mere public carrying of a handgun would terrify people. In fact, the opposite seems to have been true. As time went on, domestic culture in England softened any terror that firearms might once have conveyed. Thus, whatever place handguns had in English society during the Tudor and Stuart reigns, by the time we reached the 18th century and near the founding, they had gained a fairly secure footing in English culture. At the very least, we cannot conclude from this historical record that, by the time of the founding, English law would have justified restricting the right to publicly bear arms suited for self-defense only to those who demonstrate some special need for protection. Respondents next point us to the history of the colonies and early republic, but there is little evidence of an early American practice of regulating public carry by the general public. This should come as no surprise. English subjects found the colonies at about that time. England had itself begun to eliminate restrictions on the ownership and use of handguns. In the colonial era, respondent points to only 3 restrictions on public carry. For starters, we doubt that 3 colonial regulations could suffice to show a tradition of public carry regulations. In any event, even looking at these laws on their own terms, we are not convinced that they regulate public carry akin to the New York law before us. 2 of the statutes were substantively identical. Colonial Massachusetts and New Hampshire both authorized justices of the peace to arrest all affrayers, rioters, disturbers, or breakers of the peace, and such as shall ride or go afraid offensively by night or day in fear or affray of their majesties' liege people. In particular, respondents amici argue that offensive arms in the 1600s and 1700s were what Blackstone and others referred to as dangerous or unusual weapons. A category they say included firearms. Respondents, their amici, and the dissent all misunderstand these statutes. Far from banning the carry of any class of firearms, they merely codified the existing common law offense of bearing arms to terrorize the people, as had the Statute of Northampton itself. For instance, the Massachusetts statute provide going armed offensively in fear or affray of the people, indicating that these laws were modeled after the Statute of Northampton to the extent that the statute would have been understood to limit public carry in the late 1600s. Moreover, it makes very little sense to read these statutes as banning the public carry of all firearms just a few years after Chief Justice Holt, in Sir John Knight's case, indicated that the English common law did not do so. Regardless, even if respondents' reading of these colonial statutes were correct, it would still do little to support the restrictions on the public carry of handguns today. At most, respondents can show that colonial legislatures sometimes prohibited the carrying of dangerous and unusual weapons, a fact we already acknowledged in Heller. Drawing from this historical tradition, we explained that the Second Amendment protects only the carrying of weapons that are those in common use at the time, as opposed to those that are highly unusual in society at large, which, again, I detest. This is stupid. This is big stupid. Does that mean a weapon is not protected if it's expensive and new? I detest that. I detest that element. Thus, even if... talking about how handguns are the quintessential self-defense weapon. Thus, even if these colonial laws prohibited the carrying of handguns because they were considered dangerous and unusual weapons in the 1690s, they provide no justification for laws restricting the public carry of weapons that are unquestionably in common use today. The third statute invoked by respondents was enacted in East New Jersey in 1686. It prohibited the concealed carry of pocket pistols or other unusual or unlawful weapons, and it further prohibited planters from carrying all pistols unless in military service or if strangers when traveling through the province. These restrictions do not meaningfully support respondents. The law restricted only concealed carry, not all public carry, and its restriction applied only to certain unusual or unlawful weapons, including pocket pistols. It also did not apply to all pistols, let alone all firearms. Pocket pistols had barrel lengths of perhaps 3 or 4 inches, far smaller than the 6-inch to 14-inch barrels found on other belt and hip pistols that were commonly used for lawful purposes in the 1600s. I don't like what they're doing. Moreover, the law prohibited only the concealed carry of pocket pistols. It presumably did not, by its terms, touch the open carry of larger, presumably more common pistols, except as to planters. In colonial times, a planter was simply a farmer or plantation owner who settled new territory. While the reason behind the singular restriction is not entirely clear, planters may have been targeted because colonial-era East New Jersey was riven with strife and excitement between planters and the colony's proprietors respecting titles to the soil. In any event, we cannot put meaningful weight on this solitary statute. First, although the planter restriction may have prohibited the public carry of pistols, it did not prohibit planters from carrying long guns for self-defense, including the popular musket and carbine. Second, it does not appear that the statute survived for very long. By 1694, East New Jersey provided that no slave be permitted to carry any gun or pistol into the woods or plantations unless their owner accompanied them. If slave-owning planters were prohibited from carrying pistols, it is hard to comprehend why slaves would have been able to carry them in the planter's presence. Moreover, if there is no evidence that the 1686 statute survived the 1702 merger of East and West New Jersey. At most, 8 years of history in half of a colony, roughly a century before the founding, sheds little light on how to properly interpret the Second Amendment. Pretty good. Yeah, we found the racisms. All right. Respondents next direct our attention to the late 18th century and early 19th century statutes, but each parallels the colonial statutes already discussed. 1786 Virginia statute provides that no man, great or small, shall go nor ride armed by night nor by day in fairs or markets or other places in terror of the country. A Massachusetts statute from 1795 commanded justices of the peace arrest all affrayers, rioters, disturbances. This all goes back to the statute of Northampton, right? Where it's just like a public terror law. And an 1801 Tennessee statute likewise required any person who would publicly ride or go armed to the terror or the people or privately carry any dirk, large knife, pistol, or any other dangerous weapon to the fear or terror of any person to post a surety. Otherwise, he continued violation of the law would be punished as a breach of the peace or riot at common law. A by now familiar thread runs through these three statutes. They prohibit bearing arms in a way that spreads fear or terror among the people. As we have already explained, Chief Justice Holt in Sir John Knight's case interpreted this in terram populi element to require something more than merely carrying a firearm in public. Respondents give us no reason to think that the founding generation held a different view. Thus, all told, in the century leading up to the Second Amendment and in the first decade after its adoption, there is no historical basis for concluding that the pre-existing right enshrined in the Second Amendment permitted broad prohibitions on all forms of public carry. Only after the ratification of the Second Amendment in 1791 did public carry restrictions proliferate. Respondents rely heavily on these restrictions, which generally fell into three categories: common law offenses, statutory prohibitions, and surety statutes. None of these restrictions impose a substantial burden on public carry analogous to the burden created by New York's restrictive licensing regime. Under common law offenses, as during the colonial and founding periods, the common law offenses of affray or going armed to the terror of the people continued to impose some limits on firearm carry in the antebellum period. But as with the earlier periods, there is no evidence indicating that these common law limitations impaired the right of the general population to peaceable public carry. For example, the Tennessee Attorney General once charged a defendant with the common law offense of affray, arguing that the man committed the crime when he armed himself with dangerous and unusual presence in such a manner as will naturally cause terror to the people. More specifically, the indictment charged that Simpson, with force and arms being affrayed in a warlike manner, unlawfully into the great terror and disturbance of diverse good citizens, did make an affray. The Tennessee Supreme Court quashed the indictment, holding that the statute of Northampton was never part of Tennessee law. But even assuming that Tennesseans' ancestors brought with them the common law associated with the statute, the Simpson Court found that if the statute had made as an independent ground of an affray the mere arming of oneself with firearms, the Tennessee Constitution's Second Amendment analog had completely abrogated it. At least in light of that constitutional guarantee, the court did not think it could attribute to that mere carrying of arms a necessary consequent operation as terror to the people. We got a chat from Jesse Quiz. I understand the reasoning, but I still find it wild how ancient laws from other countries can be used to infringe on our modern American rights. Well, they haven't done it yet. They're kind of like talking down on them, ancient laws. Perhaps more telling was the North Carolina Supreme Court's decision in State v. Huntley. Unlike the Tennessee Supreme Court in Simpson, the Huntley Court held that the common law offense codified by the statute of Northampton was part of the state's law. However, consistent with the statute's long-settled interpretation, the North Carolina Supreme Court acknowledged that the carrying of a gun for the lawful purpose per se constitutes no offense. Only carrying for a wicked purpose with a mischievous result constituted a crime. Other state courts likewise recognized that the common law did not punish the carrying of deadly weapons per se, but only the carrying of such weapons for the purpose of an affray and in such manner as to strike terror to the people. Therefore, those who sought to carry firearms publicly and peaceably in antebellum America were generally free to do so. Statutory prohibitions. In the early to mid-19th century, some states began enacting laws that prescribed the concealed carry of pistol and other small weapons. As we recognize in Heller, the majority of 19th century courts, to consider the question, held that these prohibitions on carrying weapons were lawful under the Second Amendment or state analogs. Respondents unsurprisingly cite these statutes and decisions upholding them as evidence that the states were historically free to ban public carry. In fact, however, the history reveals a consensus that states could not ban public carry altogether. Respondents cited opinions agreed that concealed carry prohibitions were constitutionally only if they did not similarly prohibit open carry. Second. Okay. Looks like we've got movement on the Senate gun control bill. Roll call isn't posted. Likely going to get 64, 65. 65 senators just voted to advance the Bipartisan Safer Communities Act. Okay. So, yeah. Them not being able to ban carry completely was true in Alabama. It was also true in Louisiana. Kentucky, meanwhile, went one step further. The state Supreme Court invalidated a concealed carry prohibition in 1822. The Georgia Supreme Court's decision in Nunn in 1846 is particularly instructive. Georgia's 1837 statute broadly prohibited wearing or carrying pistols as arms of offense or defense without distinguishing between concealed and open carry. To the extent the 1837 Act prohibited carrying a certain weapon secretly, the court explained it was valid. But to the extent the Act also prohibited bearing arms openly, the court went on, it was in conflict with the Constitution and void. The Georgia Supreme Court's treatment of the state's general prohibition on the public carrying of handguns indicates that it was considered beyond the constitutional pale in antebellum America to altogether prohibit public carry. Finally, we agree that Tennessee's prohibition on carrying publicly or privately any belt or pocket pistol was on its face uniquely severe. That said, when the Tennessee Supreme Court addressed the constitutionality of a substantively identical successor provision, the court read this language to permit the public carry of larger military-style pistols because any categorical provision on their carry would violate the constitutional right to keep arms. All told, these antebellum state courts' decisions evince a consensus view that states could not altogether prohibit the public carrying of arms protected by the Second Amendment or state analogs. Surety statutes. So these are an interesting class of restrictions that were common back then. So let's see how those compare. In the mid-19th century, many jurisdictions began adopting surety statutes that required certain individuals to post bond before carrying weapons in public. Although respondents seize on these laws to justify the proper cause restriction, their reliance on them is misplaced. These laws were not bans on public carry, and they typically targeted only those threatening to do harm. As discussed earlier, Massachusetts had prohibited riding or going armed offensively to the fear or terror of the good citizens of this Commonwealth. So then it cites, if any, a later Massachusetts law here. So in short, the Commonwealth required any person who was reasonably likely to breach the peace and who, standing accused, could not prove a special need for self-defense to post a bond before publicly carrying a firearm. So it was like, one of the best things that the government could show for themselves was that if you had already proven that you were a troublemaker, right, you would just have to pay a bond, and then you'd still be able to carry a bond against your, future troublesome conduct. And that's how they somehow, justify banning, effectively, the carry of arms. It's pretty stupid. So yeah, between 1838 and 1871, 9 other jurisdictions adopted variants of the Massachusetts law. Contrary to the government's position, these reasonable cause laws in no way represented the direct precursor to the proper cause requirement. While New York presumes that the individuals have no public carry right without a showing of heightened need, the surety statutes presume that the individuals had the right to public carry that could be burdened only if another could make a specific showing of reasonable cause to fear an injury, breach, or breach of the peace. As William Rawle explained in an influential treatise, an individual's carrying of arms was sufficient cause to require him to give surety of the peace only when attended with the circumstances giving just reason to fear that he proposes to make an unlawful use of them. Then, even on such a showing, the surety laws did not prohibit public carry in locations frequented by the general community. Rather, an accused arms bearer could go on carrying without criminal penalty so long as he posted money that would be forfeited if he breached the peace or injured others, a requirement from which he was exempt if he needed self-defense. Thus, unlike New York's regime, a showing of special need was required only after an individual was reasonably accused of intending to injure another or breach the peace. And even then, proving special need would simply avoid a fee rather than a ban. All told, therefore, under surety laws, everyone started out with robust carrying rights, and only those reasonably accused were required to show a special need in order to avoid posting a bond. These antebellum special need requirements did not expand carrying for the responsible. It shrank burdens on carrying by the allegedly reckless. One court of appeals has nonetheless remarked that these surety laws were a severe constraint on anyone thinking of carrying a weapon in public. That contention has little support in the historical record. Respondents cite no evidence showing the average size of surety postings. And given that surety laws were intended merely for prevention and were not meant as any degree of punishment, the burdens these surety statutes may have had on the right to publicly carry was likely too insignificant to shed light on New York's proper cause standard, a violation of which could carry a 4-year prison term or a $5,000 fine. In Heller, we noted that founding-era laws punishing unlawful discharge with a small fine and forfeiture of the weapon, not with significant penalties, likely did not prevent a person in the founding era from using a gun to protect himself or his family from violence, or that if he did so, the law would be enforced against him. Similarly, we have little reason to think that the hypothetical possibility of posting a bond would have prevented anyone from carrying a firearm for self-defense in the 19th century. Besides, respondents offer little evidence that authorities ever enforced by surety laws. Yeah, we know. Like, and this is kind of why we don't know how much they were posted, because they probably never actually gave force to them. The only record case that we know of involving a justice of the peace declining to require a surety, even when the complainant alleged that the arms bearer did threaten to beat, wound, maim, and kill him. Neat. And one scholar who canvassed 19th century newspapers, which routinely reported on local judicial matters, found only a handful of other examples in Massachusetts and the District of Columbia, all involving black defendants who may have been targeted for selective or pretextual enforcement. That is surely too slender a reed on which to hang a historical tradition of restricting the right to public carry. Respondents also argue that surety statutes were severe restrictions on firearms because the reasonable cause to fear standard was essentially pro forma, given that merely carrying firearms in populous areas breached the peace per se. But that is a counterintuitive reading of the language that the surety statutes actually used. If the mere carrying of handguns breached the peace, it would be odd to draft a surety statute requiring a complainant to demonstrate reasonable cause to fear an injury or breach of the peace, rather than a reasonable likelihood that the arms bearer carried a covered weapon. After all, if it was the nature of the nature of the weapon rather than the manner of carry that was dispositive, then the reasonable fear requirement would be redundant. Moreover, the overlapping scope of surety statutes and criminal statutes suggests that the former were not viewed as substantial restrictions on public carry. For example, when Massachusetts enacted its surety statute in 1836, it reaffirmed its 1794 criminal prohibition on going armed offensively to the terror of the people. And Massachusetts continued to criminalize the carrying of various dangerous weapons well after passing the 1836 surety statute. Similarly, Virginia had criminalized the concealed carry of pistols since 1838, nearly a decade before it enacted its surety statute. It is unlikely that these surety statutes constituted a severe restraint on public carry, let alone a restriction tantamount to a ban, when they were supplemented by direct criminal prohibitions on specific weapons and methods of carry. To summarize, the historical evidence from the antebellum America does not demonstrate that the manner of public carry was subject to reasonable regulation. Under the common law, individuals could not carry deadly weapons in a manner likely to terrorize others. Similarly, although surety statutes did not directly restrict public carry, they did provide financial incentives for responsible arms carrying. Finally, states could lawfully eliminate one kind of public carry, concealed carry, so long as they left open the option to carry openly. None of these historical limitations in the right to bear arms approach New York's proper cause requirements because none operated to prevent law-abiding citizens with ordinary self-defensive needs from carrying arms in public for that purpose. Evidence from around the adoption of the 14th Amendment also fails to support the government's position. I think we can just kind of keep going. Damn, they really... For the most part, respondents in the United States ignore the outpouring of discussion of the right to keep and bear arms in Congress and in public discourse as people debated whether and how to secure constitutional rights for newly free slaves. Of course, we are not obliged to sift the historical materials for evidence to sustain New York statute. That is respondents' burden. Nevertheless, we think a short review of the public discourse surrounding Reconstruction is useful in demonstrating how public carry for self-defense remained a central component of the protection that the 14th Amendment secured for all citizens. A short prologue is in order. Even before the Civil War commenced in 1861, this court indirectly affirmed the importance of the right to keep and bear arms in public. In Dred Scott v. Stanford, Chief Justice Taney offered what he thought was a parade of horribles that would result from recognizing that free blacks were citizens of the United States. If blacks were citizens, Taney fretted, they would be entitled to the privileges and immunities of citizens, including the right to keep and carry arms wherever they want. Thus, even Chief Justice Taney recognized, albeit unenthusiastically in the case of blacks, that public carry was a component of the right to keep and bear arms. A free blacks were often denied. That is a right that free blacks were often denied in antebellum America, and that's very true. After the Civil War, of course, the exercise of this fundamental right by freed slaves was systematically thwarted. This court has already recounted some of the Southern abuses violating blacks' rights to keep and bear arms. See McDonald. Which noted the systematic efforts made to disarm blacks. Pistols, old muskets, and shotguns were taken away from freed slaves as such weapons would be wrested from the hands of lunatics. In the years before the 39th Congress proposed the 14th Amendment, the Freedmen's Bureau regularly kept it abreast of the dangers to blacks and Union men in the postbellum South. The reports described how blacks used publicly carried weapons to defend themselves and their communities. For example, the Bureau reported that a teacher from a freedmen's school in Maryland had written to say that because of attacks on the school, both the mayor and sheriff have warned the colored people to go armed to school, which they do, and that the superintendent of schools came down and brought the teacher a revolver for his protection. Neat. Witnesses before the Joint Committee on Reconstruction also described the depredations visited on Southern blacks and the efforts they made to defend themselves. One Virginia music professor related that when two Union men were attacked, they drew their revolvers and held their assailants at bay. An assistant commissioner to the Bureau from Alabama similarly reported that men were robbing and disarming Negroes upon the highway. Blacks had procured great numbers of old army muskets and revolvers, particularly in Texas, and employed them to protect themselves with vigor and audacity. Saying the stream died? Okay. Vigor and audacity. On July 6, 1868, Congress extended the 1866 Freedmen's Bureau Act and reaffirmed that freedmen were entitled to the full and equal benefit of all laws and proceedings concerning personal liberty and personal security, including the constitutional right to keep and bear arms. That same day, a Bureau official reported that freedmen in Kentucky and Tennessee were still constantly under threat. No Union man or Negro who attempts to take any active part in politics or the improvement of his race is safe a single day, and nearly all sleep upon their arms at night and carry concealed weapons during the day. Of course, even during Reconstruction, the right to keep and bear arms had limits. But those limits were consistent with the right of the public to peaceably carry handguns for self-defense. For instance, when General D.E. Sickles issued a decree in 1866 preempting South Carolina's black codes, which prohibited firearm possession by blacks, he stated, "The constitutional rights of all loyal and well-disposed inhabitants to bear arms will not be infringed. Nevertheless, this shall not be construed to sanction the unlawful practice of carrying concealed weapons. And no disorderly person, vagrant, or disturber of the peace shall be allowed to bear arms." Around the same time, the editors of the Loyal Georgian, a prominent black-owned newspaper, were asked by a colored citizen whether colored persons have a right to own and carry firearms. The editors responded that blacks had the same right to own and carry firearms that every other citizen have. And borrowing language from a Freedmen's Bureau circular, the editors maintained that any person, white or black, may be disarmed if convicted of making an improper or dangerous use of weapons, even though no military or civil officer has the right or authority to disarm any class of people, thereby placing them at the mercy of others. As for Reconstruction-era state regulations, there was little innovation over the kinds of public carry restrictions that had been commonplace in the early 19th century. For instance, South Carolina in 1870 authorized the arrest of all who go armed offensively to the terror of the people. That's crazy. Parroting earlier statutes that codified the common law offense. That same year, after it cleaved from Virginia, West Virginia enacted a certi statute nearly identical to the one it inherited from Virginia. Also in 1870, Tennessee essentially reenacted its 1821 prohibition on the public carrying of handguns, but as explained above, Tennessee courts interpreted that statute to exempt large pistols suitable for military use. Respondents in the United States, however, direct our attendance primarily to two late 19th century cases in Texas. In 1871, Texas law forbade anyone from carrying on or about his person any pistol unless he has reasonable grounds for fearing an unlawful attack on his person. The Texas Supreme Court upheld that restriction in English v. State. The court reasoned that the Second Amendment and the state's constitutional analog protected only those arms as are useful and proper to an armed militia, including holster pistols, but not other kinds of handguns. Beyond that constitutional holding, the English court further opined that the law was not contrary to public policy, and given it made all necessary exceptions, allowing deadly weapons to be carried as a means of self-defense, and therefore fully covered all wants of society. 4 years later, in State v. Duke, the Texas Supreme Court modified its analysis. The court reinterpreted Texas's state constitution to protect not only military-style weapons, but rather all arms as are commonly kept according to the customs of the people and are appropriate for open and manly use in self-defense. On that understanding, the court recognized that in addition to holster pistols, the right to bear arms covered the carry of such pistols at least as are not adapted to being carried concealed. Nonetheless, after expanding the scope of firearms that warranted state constitutional protection, Duke held that requiring any pistol bearer to have reasonable grounds for fearing an unlawful attack on one's person was a legitimate and highly proper regulation of handgun carriage. Yeah, manly use. Duke thus concluded that the 1871 statute appeared to have respected the right to carry a pistol openly when needed for self-defense. We acknowledge that the Texas cases support New York's proper cause requirement, which one can analogize to Texas's reasonable ground standard. But the Texas statute and the rationale set forth in English and Duke are outliers. In fact, only one other state, West Virginia, adopted a similar public carry statute before 1900. The West Virginia Supreme Court upheld that prohibition, reasoning that no handguns of any kind were protected by the Second Amendment, a rationale endorsed by no other court during this period. The Texas decisions, therefore, provided little insight into how postbellum courts viewed the right to carry protected arms in public. In the end, while we recognize the support that postbellum Texas provides for respondents' view, we will not give disproportionate weight to a single state statute and a pair of state court decisions. As in Heller, we will not stake our interpretation of the Second Amendment upon a single law in effect in a single state that contradicts the overwhelming weight of other evidence regarding the right to keep and bear arms for defense in public. Finally, respondents point to the slight uptick in gun regulation during the late 19th century, principally in the Western territories. As we suggested in Heller, however, late 19th century evidence cannot provide much insight into the meaning of the Second Amendment when it contradicts earlier evidence. Here, moreover, respondents' reliance on late 19th century laws has several serious flags, even beyond their temporal distance from the founding. The vast majority of the statutes that respondents invoke come from the Western territories. 2 territories prohibited the carry of pistols in towns, cities, and villages, but seemingly prohibited the carry of rifles and other long guns everywhere. 2 others prohibited the carry of nearly all firearms in towns, cities, and villages, including long guns. And 1 territory completely prohibited public carry of pistols everywhere, but allowed the carry of shotguns or rifles for certain purposes. These territorial restrictions fail. Good sir, we're here for feet pics and anime girls. Why are you talking? I'm sorry, I didn't mean to. The vast majority of statutes that respondents invoke, 2 others. These territorial restrictions fail to justify New York's proper cause requirement for several reasons. First, the bare existence of these localized restrictions cannot overcome the overwhelming evidence of an otherwise enduring American tradition permitting public carry. For starters, the very transitional and temporary character of the American territorial system often permitted legislative improvisations which might not have been tolerated in a permanent setup. These territorial legislative improvisations, which conflict with the nation's earlier approach to firearm regulation, are most unlikely to reflect the origins and continuing significance of the Second Amendment, and we do not consider them instructive. The exceptional nature of these Western restrictions, I don't think it's that important. More temporary incidents. Similarly, we will not stake our interpretation on a handful of temporary territorial laws that were enacted nearly a century after the Second Amendment's adoption, govern less than 1% of the American population, and also contradict the overwhelming weight of other more contemporaneous historical evidence. Second, because these territorial laws were rarely subject to judicial scrutiny, we do not know the basis of their perceived legality. When states generally prohibited both open and concealed carry of handguns in the late 19th century, state courts usually upheld the restrictions when they exempted army revolvers or read the laws to exempt at least that category of weapons. Those state courts that upheld they're saying the same thing. They're saying the same thing again. Absent any evidence explaining why these unprecedented prohibitions on all public carry were understood to comport with the Second Amendment, we fail to see how they inform the origins and continuing significance of the amendment. Finally, these territorial restrictions deserved little weight because they were consistent with the transitory nature of territorial government, short-lived. Some were held unconstitutional shortly after passage. Wow. Beyond these territories, respondents identify one western state, Kansas, that instructed cities with more than 15,000 inhabitants to pass ordinances prohibiting the public carry of firearms. By 1890, the only cities meeting the population threshold were Kansas City, Topeka, and Wichita. Even if each of these cities enacted prohibitions by 1890, their combined population accounted for only 6.5% of Kansas's total population. Although other Kansas cities may have also restricted public carry unilaterally, the lone late 19th century state law respondents identified does not prove that Kansas meaningfully restricted public carry, let alone demonstrate a broad tradition of states doing so. At the end of this long journey through the Anglo-American history of public carry, we conclude that respondents have not met their burden to identify an American tradition justifying the state's proper cause requirement. The Second Amendment guaranteed to all Americans the right to bear commonly used arms in public, subject to certain reasonable, well-defined restrictions. Those restrictions, for example, limited the intent for which one could carry arms, the manner by which one carrying arms, or the exceptional circumstances under which one could not carry arms, such as before justices of the peace and other government officials. Apart from a few late 19th century outlier jurisdictions, American governments simply have not broadly prohibited the public carry of commonly used firearms for personal defense. Nor, subject to a few late-in-time outliers, have American governments required law-abiding responsible citizens to demonstrate a special need for self-protection distinguishable from that of the general community in order to carry arms in public. Constitutional right to bear arms in public for self-defense is not a second-class right subject to an entirely different body of rules than the other Bill of Rights guarantees. Thank you. Thank you. We know of no other constitutional right that an individual may exercise only after demonstrating to government officers some special need. That is not how the First Amendment works when it comes to unpopular speech or the free exercise of religion. It is not how the Sixth Amendment works when it comes to a defendant's right to confront the witnesses against him, and it is not how the Second Amendment works when it comes to public carry for self-defense. New York's proper cause requirement violates the 14th Amendment in that it prevents law-abiding citizens with ordinary self-defense needs from exercising their right to keep and bear arms. We therefore reverse the judgment of the Court of Appeals and remand the case for further proceedings consistent with this opinion. Bam. Then we've got there's a lot more, like most of this is the concurrences and stuff. I think maybe later on we can read the concurring and dissenting opinions because they're going to be interesting. But this was pretty good. It didn't do some of the things that I was concerned it would. It did completely inexplicably endorse certain sensitive places restrictions. I don't understand why it did that. But it's pretty good. So now we have a standard. I fear that it's not terribly clear, though. What is being announced to the courts of appeal is that you have to stop doing it the way you've been doing it, which was this two-part test, right? Where they're like, oh, is it the Second Amendment? Okay, yeah, it's the Second Amendment, but do we really want to do it really bad? Right? That was the previous test. So the test right now is it Second Amendment protected conduct? That's the whole thrust of the discussion. And so the only way out for states going forward is going to be either to argue that it's not Second Amendment conduct, right? Or that it's without the scope of the text, which keep and bear arms, right? It's going to be very hard for them to do that. They're going to be trying to argue that no, this law is analogous to laws that existed, and the most relevant time period will be immediately before the founding, followed by the area leading up, the time leading up to the Civil War. That's going to be the most important information. And so what does this mean for concealed carriers in New York State with restrictions? Well, right now, nothing. It's getting sent back to the lower court, who will have to enjoin, right, this conduct. They may, there's still a chance that the court may behave insanely, right? It's happened before. What this means, though, is that May issue carry is dead. It's over. That's what this means. Confidently. As for how it should be applied going forward. So there's questions. Somebody just said, Jim Satala said, "What do you think about challenging the total prohibition on felons on the basis of the surety law?" So I think that felon disarmament is ripe for review at this point, because right now, the way the federal prohibition works is there is no way to get your rights back unless you bribe the president, right? The president has to pardon you. Let me go back here. And so it'll be a similar situation that New York suffers right here. They'll have to say, oh, well, no, these early things where, like, you know, arms were taken away from people who were considered disaffected, who were considered dangerous. But the thing is that there was never a permanent disenfranchisement of arms. It was usually limited to a fixed period of time, at which point even the government would give you your guns back. So it's going to be hard. It's going to be hard. It'll be very hard to bring that case. Because that's going to be something that they desperately aren't going to want to do. So I think that under this standard, categorical felon disenfranchisement is unconstitutional. Like, you know, faithfully applied if the Supreme Court were to apply it. Right? If you go through the same analysis they did, it's like, yeah, there were some restrictions, but like all of the restrictions were, you know, I have not found a permanent disenfranchisement law, and I've looked. I haven't looked as much as my colleague has, but I'm not aware of a permanent disenfranchisement law. Certainly not one that implicates, like, you know, the current definition of a felony. Right? It was like actual treason and like hyper murder. You know. Okay. Bob Dodson asked, once you finish with felons, how hard does the unusual part exclude any chance at abolishing NFA restrictions? Feels mixed. It's not close in time to 14th, but are NFA items not unusual? Okay, so here's the thing. It's going to depend. Because they can't say that, oh, you know, machine gun short barrel shotguns are unusual now, right? Because, well, no, they're unusual because they've been restricted. And remember, it's dangerous and unusual. So, and dangerous means uniquely dangerous with respect to the thing itself. The way I would argue that is that no firearms, you know, no shoulder-bearing regular projectile firearms could fall into dangerous and unusual, including machine guns, because there is nothing acutely dangerous about a machine gun as compared to any other self-loading firearm. And also, and again, dangerous and unusual. Well, what's the definition of unusual? Is it something that's just expensive, right? Like, you know, what's going on there? It has to be principled. Like, when you say dangerous and unusual, they're talking about, like, something very serious, right? They're talking about, like, weapons of affray, like, of serious implication. So, thank you so much for the super chat, Bob. Anybody else? Any questions? Am I still alive? A little bit. I'm twitching. Dangerous. Hey, guns, tripwires. Yeah, I don't know, guys. The dangerous and unusual thing is, it's fertile ground. It's very fertile ground. Unfortunately, I think there's some wiggle there that certainly the lower court justices will cling to that. I anticipate. So, I mean, let's talk about the real stuff that's going to happen after this. Now that we've got a more clear standard, what's going to happen to the assault weapon laws? They're going to make the argument that assault weapons, you know, and yes, I use that term and I own it, because guess what? Yeah, I have a right to them. I have a right to an assault weapon. I have a right to a light intermediate cartridge firearm. So in these jurisdictions where they ban assault weapons, they're going to make the argument that they're dangerous and unusual. And I think we'll see the courts of appeal by that. So that's going to be the next, you know, That's going to be the next point that we'll need the Supreme Court to resolve. So what is dangerous and unusual? Where's the cutoff? But so yeah, again, dangerous and unusual. Well, they're used all over the country. And so the dishonest thing that it's going to be done by the courts of appeal on this is they're going to say, well, they're unusual here because we already banned them. Right? They're going to put the cart before the horse. It's just what they're going to do. They're just going to do it. Okay, we got a question from Jesse J. Quiz. California was saying standard capacity mags were uncommon per California constitutional until Freedom Weekend. Now we need an NFA Freedom Weekend to make that point. It's interesting because remember the timing, right? The timing is important. They have to have been dangerous and unusual before they were regulated. Otherwise, it's an unprincipled question. Otherwise, the question means nothing. It means you could ban anything. And say, oh, well, it's unusual. Look, we banned it. Nobody's got it. Right? I love that too many choices. Yeah, no, like the implicit argument, right, that when you talk about these are like dangerous, unusual weapons of war or whatever, and then the cops use them on us. Like, yeah, too many choices said the cops are using dangerous and unusual weapons on citizens. Can't have it both ways. That's right. So I have to donate to get your attention? No, I was reading people who didn't donate. Just, it helps when your thing is blue. No. In summary, more and more lawsuits are needed. Yes. It's the only way it gets done. I mean, look, when was the last time the Supreme Court looked at it? It's been over a decade. Right? It's been 12 years. And it took the lower courts like dumping on the standards, on dumping on the right for that long to get the court to look at it again. So yeah, we need to do a lot of lawsuits, and we need to give the courts of appeal a lot of opportunities to cock it up, right? Because that's the only point the Supreme Court steps in, is once the courts have cocked it up, and once they've created a fissure, once they've created a split between the jurisdictions, which is what they always do. You know, part of me, I do wish that my federal circuit would have a little bit of ball, you know, would have a little ball and actually put some of the decisions on our side of the split. Sixth Circuit can do that, you know, Fifth Circuit. We got a question from Kevin Patrick Jr. A precocious high schooler could have written a better dissent than the primary one. It's ludicrously bad. Oh, I'm excited to read that. Well, you guys think I should come on and read it later? Because I've been on for too long. I have like to do some other things. You should definitely go on it with Nick Rakita law tonight to discuss this and possible angles today. Yeah, if Rakita emails me, he's got my contact information. What's the justice distribution, party lines? It's what you'd expect. You're looking mad cute, bro. Thank you, new user. But yeah, boys, I think that's Yep. All right, boys. I think that's it for now. I will a little later. I've got some stuff to do. If you guys want, I will get on and read the concurring and dissenting opinions. I won't go as in depth because it's not really binding, but you know. Yeah, boys, no worries. We got Liberty Cave. We can dance today. We better get back to work tomorrow. Our enemies are not dancing today. They are working against us. That is true. We got to start thinking of all of the ways that this, and this is what I'm going to be thinking. I'm going to be thinking about what's the best place to apply this standard, right? And it's hard. It's not as easy as you think, because we've got some examples of its application, and it could be dangerous, right? Could create some bad law, and, you know. Well, Sam Fisher, I don't think anyone's like currently rethinking total felon disarmament. What I think is that with this standard, we could attack it. But yeah. Well, anyway, boys, that's it for now. Thank you all so much for tuning in. I'm glad to actually have some decent news for once. And later on, we'll look at the rest of the stuff. I'll probably jump on it like probably 5 or 6 Eastern to do that. All right, boys.